Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. In this video, I'll be talking about the mistake under Indian Contract Act 1872. So, mistake is in general meaning is something that does not work in a search of solution. Word mistake is used interchangeably with error in law, misunderstanding or erroneous belief about a material fact may prevent the formation of a valid contract. According to Section 10 of Indian Contract Act 1872, free consent of parties is an essential element of any contract. Section 14 of the Indian Contract Act states the free consent, meaning the consent not caused by any coercion or undue influence, fraud, misinterpretation, and mistake. If we go by the definition, mistake is defined in Indian Contract Act under that Section 20, Section 21 and 22 deals with the concept related to mistake, and it can be defined as any action, decision or judgment that is produced an unwanted and unintentional result. A mistake is said to have occurred where the parties intending to do one thing by error do something else. In case Phillips versus Brooks Limited is an English contract law case concerning mistake. It was held in the case that a person is deemed to contract with the person in front of them for them unless they can substantially prove that they, instead of them, intended to deal with another person. Types of mistakes. There are two types of mistakes: mistakes of law and mistakes of fact. So the mistake of law means any contract which is performed by the parties without knowing the law which is essential for the contract, and Section 21 of the Indian Contract Act deals with the effect of mistake of law. In case Grant versus Bog, the person was not knowing the clauses of the Immigration Act 1971 for staying beyond the time limit by the leave. He cannot apply defense under the mistake of law. Then the second comes mistake of fact, which means any contract which is performed by the parties without knowing any material fact which is essential for the contract. Section 20 and 22 of the Indian Contract Act deals with the mistake of act, and mistake of fact is of three types: bilateral, unilateral, and a common mistake. There was a landmark case for mistake of fact, the state of Maharashtra versus Mayor Hans George. In this case, officer is of court and he was ordered to arrest Mayor Hans George. The officer arrested someone Y, but the officer arrested someone Z by mistake. As he believes Z is Y, here A can take the base of bona fide intention or as a defense of mistake of fact. So there comes a common mistake when both parties are mistaken from the fact related to the subject matter of the agreement. The court can declare the entire agreement as void in such kind of mistake. If the contract contains a small error relating to the subject matter, then there is very less chance that the court will rule that the contract is void. If any party of the contract that does not contain a mistake is still valid. So I may conclude by saying that according to Section 10 of Indian Contract Act 1872, all agreements are contracts if they are made by the free consent of the parties competent to the contract for lawful consideration and with a lawful object. According to Section 14 of the Indian Contract Act, consent is said to be free when it is not caused by mistake, subject to the provisions of Section 20, 21 and 22. The mistake can be of two types: mistake of law and mistake of fact.